that they filed a notice of appeal to appeal the magistrate decision, finding that they are extraditable. It so happened that the prosecution services in Eswatini realized that the notice of appeal so filed was null and void for reasons of being filed out of time, and further, it was filed after the Minister of Justice has already given an order for those two South African citizens to be brought to South Africa. As a result thereof, an application was brought by the prosecution services in the High Court in Eswatini for the High Court to declare the notice of appeal being null and void. The two Ndimande brothers opposed that application. The judgment or the ruling thereof is today. It will be delivered at 11:30. That is the correspondence we have received from our Eswatini prosecution team. Mention needs to be made of the following. Mr. Dlamini, who is appearing for accused number 1 in this matter, is an instructing attorney for those two Ndimande brothers in Eswatini. And his law firm instructed Advocate Mlochwa, who is also present in these proceedings, to argue the opposition of the state's application for the declaration of the notice of appeal being null and void. Mention also needs to be made of the fact that the prosecution team indicated to us that even though they, as the prosecution team, indicated the agency of the matter because of these matters in South Africa, the Ndimande brothers in their papers indicated that there was no agency. With that brief history then, Your Worship, we wish to indicate to the court that the extradition process is at the stage that it may reach its finality today. And if one has to weigh the interest of justice in the next perhaps week or so, they might be joined in this matter. The state did not hide the fact right from the onset of these proceedings of the existence of provisional arrests and the arrests and the proposed extradition process that was unfolding. When the matter was adjourned until today, we catered for this process to unfold to its finality. And we were of the view that by the 29th of November, it would have been finalized. With that being said, may I stress the following. The prosecution services at Eswatini, on the request from the Republic of South Africa, did everything possible to have the two Ndimande brothers brought to South Africa. The first leg thereof was the Magistrates Court, which granted the application for the extradition. The judgment is there. Despite some delays, further thereto, the administration of the Kingdom of Eswatini, through the Minister of Justice in that country, issued an order that they should be extradited to South Africa. As we stand, they should be brought to South Africa. Enjoying their rights to appeal, a notice which appeared to be null and void was filed, which became a subject of a High Court matter, which ruling is coming out today. We therefore request that this matter be adjourned to allow the addition of the two demanded brothers as accused number 3 and 4 in this matter. Thank you, Bishop.
Anything, he is out on bail. Accused number 2 is in custody. He's waiting the outcome of the bail application, which matter is postponed to the 17th of December. So in this matter, not the other matters, but this matter, what is the big deal?
May it please the court to concede that accused number 1 is out on bail, but the prejudice that is suffering, Your Worship, is that of financial. There's a further adjournment. He's paying for his legal fees, and I say the prejudice that is suffering outweighs the prejudice that the state will suffer.
But he is out on bail in this case.
That is correct, Your Worship, but he is paying legal fees today for this matter to be finalized for indictment, and the state is seeking yet another adjournment. Who is going to cover those fees? There is material prejudice, Your Worship, that he is suffering.
And just to add, Your Worship, while we, on the aspect of prejudice, is that Advocate Tibz has still not indicated to the court how long is the adjournment that he is seeking. Because like Your Worship says, accused number 1 is already on bail. Accused number 2 has a decision pending, which will be delivered on the 17th. Now, on the 17th, if that goes against him, and he's now got to sit in custody till April or March next year, that is why I'm emphasizing the time of the adjournment. Because, Your Worship, I submit with respect.
March next year.
Well, we haven't heard yet, Your Worship. We haven't heard how long this adjournment is going to be. What we have heard is that the ruling will be delivered in an hour's time or so forth. So that could facilitate us coming back next week or in 2 weeks he is seeking. Because like Your Worship says, accused number 1 is already on bail. Accused number 2 has a decision pending which will be delivered on the 17th. Now, on the 17th, if that goes against him, and he's now got to sit in custody till April or March next year, that is why I'm emphasizing the time of the adjournment. Because, Your Worship, I submit with respect.
March next year.
Well, we haven't heard yet, Your Worship. We haven't heard how long this adjournment is going to be. What we have heard is that the ruling will be delivered in an hour's time or so forth. So that could facilitate us coming back next week or in 2 weeks' time. And this is why, again, I'm emphasizing the time frame. Because then the prejudice would be minimized. Because if we come back in 2 weeks' time, and depending on that decision, and if there's an appeal, and then it's going to delay it another 3 or 4 months, that impacts on prejudice, particularly in respect of accused number 2. So those are the factors. It's a simple question, Your Worship, just for him to answer.
Thank you, Bishop. May I mention this so that moving forward we are clear?
Maybe before you mention whatever you want to mention, why is the matter brought now before the judgment at Eswatini, which is due in hours' time? Why was the matter not delayed until that judgment comes out, so that we'll then talk about a judgment has already been given, this is the judgment, and we apply that this court do 1, 2, 3?
We thought of that, Your Worship. We thought of that. However, this matter, this present one, that is the second leg of the application. Remember, there's a judgment on the 17th that needs to be catered for. That is why this matter was called first, because there are 2 legs of the postponement. Firstly, let's finalize the bail. Secondly, let's join the other 2. But I take heedance of the advice by the court. Perhaps it might be advisable that we stand the matters down, all of them. We hear what the judgment is. Then we indicate to the court, this is the position, and then decide thereafter as to what and hear the submissions thereafter.
To me, that will make a lot of sense, because by then you'll know the judgment is already out. The judgment says A, B, C, and therefore, moving forward, 1, 2, 3.
Perhaps, may I request that then the matter stands down? All the matters will have to stand down, and we'll await that judgment. It might have an impact on the court's ruling of whatever application.
Mr. Dlamini? Your Worship, you seem to be over.
Your Worship, I have difficulty in it. What purposes will it serve? The judgment in Eswatini. What purpose will it serve in this matter?
But the writing is on the wall.
What is the writing, Your Worship?
We'll know what the judgment is, and then we'll take the matter further from there. The judgment can go either way. It can be for or it can be against. And then whatever the judgment, or whichever way the judgment takes, it will inform us what to do.
I'm in the hands of the court, then, Your Worship.
The last time I checked, the court doesn't have hands.